Okay, I'm here in Los Angeles, 350 West 1st Street to support a client who's getting sentenced today. Some background, I met our client through her lawyer, Alan Eisner, excellent defense attorney in Los Angeles. We've worked with Alan for more than 13 years. The guidelines are high in this case, 78 to 97 months. It's a big number. Victims will be here to speak. That's always emotional. And there's going to be prison time. The question is how long? An unfortunate development, I think, before sentencing was the government alleging that this defendant had lied in her probation report, essentially make up that she had some history of substance abuse or alcohol. As a reminder, the goal of the probation report, you want it to be honest. That's what we're told to do. I've spoken with federal judges who have said probation report isn't magic. It should just reflect the totality of the defendant's life. Any and all medical issues, including substance abuse and alcohol. So here we have someone who disclosed it openly and honestly, who has gone to counseling, yet rather than reward her for telling the truth, the government's alleging that it's a ruse and a lie, simply so she can benefit from the drug program that would take a year off of her sentence. I think conduct like that encourages people to not speak openly and honestly for fear they're going to be embarrassed and it's going to be thrown back in their face. And I don't think it's going to work. You want to know why? Truth prevails. She told the truth. She didn't make anything up. Truth prevails, and I don't think it's going to help the government. If anything, I think it's going to help our client because she told the truth. I will report back after the sentencing. Some of you may be wondering, well, probably not, but I'll tell you anyway. Justin, you usually wear a suit and a tie to these sentencing hearings. Yes, I'm very superstitious. It's a baseball thing. I've worn the same top to 2 recent sentencings via Zoom, and both of our clients got well below guideline sentences. So I put the suit and tie away, and I got this top on. It's actually the second time I've worn it this week, with hopes that it brings some good luck to our client, who has clearly accepted responsibility, who is clearly working to make amends. And although the sentencing is here in Los Angeles, she lives in Texas and will most likely go to a prison in Texas. Let's see what happens. I'll report back shortly. Okay, just finished the sentencing hearing. Wow, it was difficult, and I've attended so many of them over the years. Before our client got sentenced, another white-collar sentencing took place. And in this case, it was a grandmother facing deportation back to her home country of China for engaging in a large fraud that was over $2 million. Something that I think hurt the defendant, and this comes back to something that Judge Gonzalez-Rogers said at a conference I attended several months ago. She said, some people who speak on behalf of the defendant or who write letters on behalf of the defendant mistakenly or purposely continue to enable the defendant's character. They excuse it. And I think the judge said, if you are going to turn in a letter that enables the conduct, don't turn it in, because it can absolutely work against you. And I think we saw some of that when the defendant's son spoke eloquently, and I empathize with him. It's awful that his mother, a grandmother, is going to prison, yet in his statement, he was excusing, blaming others she didn't know that she was doing, yet in the next vein talk about how she was an entrepreneur and built businesses and supporting the family. So in one vein, she's inexperienced, she didn't know what she was doing. In the next vein, she's a very seasoned executive who has built a business and helped people. It was duplicitous, and I think it's off-putting to a judge. To close this portion of that sentencing, and she got 20 months in federal prison, I think it could have been less with better planning. Do not turn in a letter if it's going to enable the conduct. The letter should follow the path that Judge Bennett told my business partner, Michael Santos, in a YouTube video. I accept full responsibility, or let me say that a little better. I'm writing on behalf of my friend Joe Smith, and in speaking with Joe, it's clear that he's accepted full responsibility for his conduct. And my goal in this letter is not to excuse his conduct, but rather share a story or two about the Joe that I know. Lastly, do not tell the judge the sentence to impose. It's off-putting. They're a federal judge. You are not. Do not tell them how to do their job. This son who finished speaking said, do not send my mom to prison. Of course you don't want your mom to go to prison. Of course the judge knows that you don't want to go to prison. Do not tell the judge how to do their job. Now, to our client's sentencing, brutal. Brutal, I tell you. U.S. Attorney opened up essentially by stating that even though our client turned herself into authorities, she should not get the 3 points for the acceptance of responsibility, and that he felt she had made statements that were not consistent. The guideline range, if you remove her 3 points for acceptance of responsibility, together with an obstruction of justice charge he wanted to add, would be 78 to 97 months. The judge, rightfully so, and as I predicted, quickly jumped in and said, wait a second. You've been in the U.S. Attorney's Office, U.S. Attorney since 1997. How many times have you not given the acceptance of responsibility credit to someone, especially when they walked in and turned themselves in? Now, of course, the U.S. Attorney said, yes, she turned herself in, but it was clear the writing was on the wall, the jig was up. True, but most people get the acceptance of responsibility credit without turning themselves in. It's only after they got caught. So the judge wasn't a buyer. I knew he wouldn't be a buyer, and he also wasn't a buyer of this approach that she was lying or conning her way in to substance abuse or alcohol history. I knew it would never work, yet the U.S. Attorney spent the first 15 minutes of his remarks discussing it. The judge confirmed when the sentence opened with our client, have you read the probation report? Yes. Do you understand the probation report? Yes. Do you understand the importance of the probation report? Yes. Asked the lawyer, Alan Eisner, have you reviewed the probation report with your client? Yes. Was she cognizant and able to understand the probation report? Yes. I share this with you because this judge asked about the probation report repeatedly, yet there are so many defendants who are told the probation report's not a big deal. It's a 10 or 15 minute interview. Earlier this week, our team began working with someone, and the actual quote from the lawyer to the client was, you don't need to begin preparing for the probation report. I would argue it's malpractice. It's horrific advice. Whether you believe it or not, whether you want to take our advice or not, listen to the advice of subject matter experts we have interviewed who continue to say the probation report will be the most important interview of your life. Whether you choose to take the advice or not is your choice. If you choose to take the advice, it's a meaningless 10-minute interview. That's your choice. And when it goes rogue or bad or things fall off a cliff, it's not your lawyer's fault. It's your fault. You knew better. When the sentencing hearing opened, the judge stated at length that the length of the fraud, more than 4 years, troubled him, together with what our client did with the money. She wasn't using it to keep the bills, just barely stay alive, barely stay afloat. She stole, called her a scam artist who used these resources simply to enrich herself and to the detriment of her employer, and there was no way that he could overlook that, no way that he could overlook the devastation he brought to the victims, to the business and the people they had to let go, that I can't overlook that. And I'm not even sure that you're not going to reoffend, but I will give you the acceptance of responsibility credit. I do not agree with the government's position that you do not have a history of substance abuse or alcohol. You documented it, you disclosed it, it's in the probation report. I don't believe that. Therefore, I'm moving the guideline range from 48 or 46 to 57 months. That was a good, huge win because the U.S. Attorney was suggesting 78 to 97. That was a good win despite some very harsh, brutal remarks from this judge, arguably the most engaging judge I've attended a lot of sentencing hearings. A lot of engagement, cutting off the defendant, the lawyers, asking questions. Impressive. Let me collect my thoughts for a moment. Then the victims spoke. When the victims spoke, it was emotional. It was brutal because it wasn't just the financial loss. It was the loss to the company and the people they had to let go. Now, when I say when I came home from prison, I didn't have any money, I didn't have any clients, I didn't know what the hell to do. I mean, I did cold walk around these streets of downtown Los Angeles peddling my book. But I attended a lot of sentencing hearings. I get emotional sitting back in those sentencing hearings. And I'd never seen a judge let the defendant speak for as long as they did today. Even my judge, Judge Wilson, in my sentencing hearing, essentially cut the victims off and said, I understand, I get it, I'm sorry. He let these victims speak for more than 20 minutes. And the longer they spoke and the more they articulated the damage that's been done to their business and their family and their dignity, it was clear, in my opinion, that she was going to get 57 months in prison. Then I saw the marshals walk in. I thought, not only is she going to get 57 months in prison, they're going to remand her to custody. This isn't going well. The victim impact statements they're just devastating. And the judge spoke at length about what she actually did with the money. As aforementioned, it wasn't taking the money to support a loved one or pay the utility bill to keep the lights on. It was stealing, it was traveling, it was Hawaii, it was jewelry, it was theft. And he repeatedly said to her, you're a scam artist and you're going to prison. After the victims were done speaking, the judge said, I'm sorry that you went through this, and I know you've been victimized, and you're strong and you're capable, and you're gonna make it back. He then said he was going to render sentence, reiterated that the defendant, despite her conduct, did turn herself in. She was entitled to the acceptance of responsibility. She was entitled to a recommendation for the drug program based on what was disclosed in the probation report. The judge also said, keep in mind, this is only a recommendation. It is up to the Federal Bureau of Prisons, but I will, based on the disclosure in the probation report, make the recommendation for the drug program. Then he rendered sentence, 46 months in federal prison with a surrender date of March 10th. Many people will ask, well, what does that mean on 46 months? How long would she actually serve? It admittedly, if the victims knew this, they'd be angry. It's part of the reason the victim was asking the judge to give her the 78 months, to give her 97 months, to give her as much time as possible. On 46 months, she'll get 15% good time, whatever that is. I only have a psychology degree from USC. I ain't great with math, but what is that, 40 months? Taking a year off potentially for the drug program, that's 28 months. A year or so for the First Step Act, 16 months, give or take. So I can understand how that could be very difficult for a victim to hear, because it's not 46 months, and it wasn't 78 months, and it wasn't 97 months. But this is the justice system. I'm biased and jaded because, well, I see the good in people. And I know that our client is apologetic and remorseful and ashamed, even if nobody else believes it, including the U.S. attorney, who made it a point to say it's unlikely she could ever pay the money back. I think they thought the same thing about me. They think that way about a lot of people. The money can be paid back. I did it. Many people have done it. And I believe that with hard work and discipline and a plan, our client can do it as well. To close, never forget the perspective of the stakeholders. Ever. The U.S. attorney was not willing to give her the acceptance of responsibility statement. She turned herself in. She did as she was supposed to do and disclose her honest, documented history of abuse in the probation report. They still called her a liar. Regardless of what they do, you've got to mitigate. You've got to prepare. You've got to demonstrate why you will never return to another courtroom, that you're remorseful, that you've learned. You've got to document and create a plan. It's an emotional hearing. I don't know it's an emotional hearing. I empathize with the victims. It's awful. I'm going to wrap it up here before I just continue to ramble. Thank you everyone for watching. Mitigate. You've got to do the lion's share of the work. It's a cynical, wretched, sickening system. They expect you to lie and to cover up.